Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Tammy Jana Swink. Case number 2021 CR 169. Ms. Swink appears from a Zoom location at the Greenwood County Courthouse. Joseph Favre appears as defense counsel. Jill Gillette appears as Greenwood County attorney. This matter comes before the court at this time for further hearing in regards to a warrant to show cause alleging probation violations, failing to report as directed, and failing to attend her Senate Bill 123 treatment as directed. Court does note that this is not the first probation review in this particular case. One announcement is made at this time, Mr. Favre.
Judge, unfortunately, I've heard it all from Miss Swink. I got an email from her mom.
You're breaking up, Joe.
I'm not able to. Sorry, Judge. Can you hear me okay now?
Okay, better now.
Do I need to move? Okay. I've not heard it all from Miss Swink. I got an email from her mother. So I hate to ask this because I know I was running late, but I need like 2 minutes to talk to her.
Very well. Let's pause these proceedings. And let's put defense counsel and the defendant in the breakout room.
Thank you.
Court at this time will proceed further in State versus Swink following a brief recess. Pertinent parties appearing as before. What announcement is made at this time?
So, Judge, I assume we're proceeding off of the amended motion to revoke that was filed by Ms. Gillette June of last year, as well as maybe the addendum, which I didn't see a new motion, but I saw Mr. Ketley filed a new request for revocation in February of this year. Is that what we're proceeding off of?
That's what I have.
I have a warrant to show cause that was filed in January based on a request by Mr. Ketley that he swore to on January 2nd.
Okay.
Alleging failing to report, failing to attend her treatment as directed.
It's
so
this is what I have as the historical issues in the case. She was sentenced to 2022. There was a revocation journal entry 12/1/22 dealing with revocation. There was a sanction done for issues on 4/16/23. There's a motion filed regarding the allegations Mr. Ketley filed in 23 in June that I filed an amended motion to revoke because there had been lots of issues happening since 12/1/23. And then for some reason, the warrant had not been either entered in correctly or something. And so a new warrant was issued in February or January or February. And then that, there had been a warrant withdrawn in August of 23 after the motion. I don't know why. And then the new warrant had issued in January 5th. Nothing has been done since the sanction on 4/16. So there was the amended motion to revoke issues and then the new warrant to show cause. So she has had a prior revocation and a prior sanction. And then we have the new issues.
Okay.
There
So I
was,
guess my question is what the court has. Go ahead. Sorry, Joe.
it's all right. My amended motion to revoke was filed in June and it's never been heard. And then we have to reissue the warrant as she was arrested in Sumner County on that warrant.
So the packet that was sent to me from the CAs has with it the warrant to show cause that was sent February 13th, 2024. That was filed in the court. That was filed in the court on February 13th. And that's the one that I think the court mentioned that it was failing to report on November 30th and failing to attend Senate bill treatment as directed. So I just want to make sure which one we're proceeding on. If it's just that one, great. If it's that one plus what Ms. Gillette's mentioning, that's fine, I guess. I just need to know what we're admitting to.
All right, it would be the court's position that we're proceeding under Mr. Ketley's affidavit and warrant to show cause issued in January. Any motion filed months before that in the view of the court is stale. At this point, we're going to proceed solely on Mr. Ketley's January allegations.
Okay. I've spoken to Ms. Swink about that, Judge, and Ms. Swink will stipulate to those violations.
All right. All right, Ms. Swink, you've heard your attorney's statement. It's his understanding that you're going to stipulate or agree that you committed the violations of alleged Mr. Ketley's recent warrant to show cause, recent saying that it was in January of this year. Those allegations were, again, failing to report as you were supposed to and failing to attend your Senate Bill 123 treatment as directed. You do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause was shown. And I need to point out that among other lesser remedies, the court could just consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things, Ms. Swing?
Yes, sir.
Do you waive a hearing in this case and stipulate and agree that you committed these failing to report and failing to attend your Senate Bill 123 treatment?
Yes, I did fail to report then.
Okay, I'm sorry, I didn't hear that last.
Yes, I did fail to report then at that time.
Okay, you did fail to report.
Yes, sir, I did fail to report during that time. I've been keeping in contact as much as possible since.
Okay. So you acknowledge that you failed to report to your probation officer, right?
Yes, sir.
And you failed to attend your Senate Bill 123 treatment as directed?
Well, I completed it all except for a little bit of it, yeah, and I've been trying to find something that matches my insurance because it came off my Senate bill. They said my Senate bill was closed.
Okay, well, Ms. Swink, this is an important issue. I'm not sure if you're admitting that violation or not. Either you completed Senate Bill 123 treatment or you didn't.
I didn't complete it all the way. I got my inpatient my completions from there.
Okay, we'll talk more about that later. All right.
Okay.
There is, the court will accept the waiver of hearing and acknowledgement that she failed to report to her officer as directed and failed to actually complete her Senate Bill 123 treatment program. These are substantial and material violations of the terms and conditions of Ms. Swink's Senate Bill 123 oriented probation in the case. I've just got one other issue I want to address. If you'll bear with me a moment, counsel.
What's your paper there? You got it.
The issue that I'm trying to research here is to whether this request for revocation of probation was still within her probation period. I do note the original sentencing date was March 31 of 2022. She was placed on probation for up to 18 months. That would have taken her to December 31 of 2023. Mr. Ketley filed this motion or this warrant to show cause in January of 2024. which appears to be within the 30-day window past expiration period that he is allowed. So not by much, but it does appear to the court that this was a timely request for revocation of probation in the case.
Your
If
Honor,
there's any
there was
disagreement, I want to hear that now. Mr. Favre?
Judge, just crunching my numbers here. Sorry. Sorry. Give me a second here. So
Oh, you're okay. Hang on. Maybe perhaps my math isn't correct here.
there was an extension done, a voluntary extension done in this case on, when was that done?
September 28th.
September 28th. And that was a 6-month extension, correct?
Okay.
Yes.
Which puts us, I think, March of 24, if my math is right, which means that we're within the time frame there. I think we're fine.
Very well. The extension document is not readily before the court. I do appreciate that clarification. We will proceed further with dispositional proceedings here. And sorry about the delay because of the court's faulty mathematics and reliance, I think, just on the papers before it. All right. Court will take recommendations from each attorney regarding an appropriate disposition. I'll start with Jill Gillette on behalf of the state.
Judge, it's the defendant's responsibility to be contacted their ISO, having to track them or try to come in. Mr. Ketley has done a lot to try to keep Ms. Swink tracked down, give her extra options, and do extra things for her. He even set up worked with her to set up mental health evaluations. She no-showed to those in the history of this case. There's information about those being set up for May 3rd and June 21st to try to help her with her mental health, because her mental health is an issue as well. She no-showed to those. She's failed to report to him as directed throughout the entirety of her supervision. The best she did was when she was in the sober living house. And when she was not to move out of Sedgwick County when she was in that sober living house. She ended up doing that, and she left without permission. She's moved around, not kept him informed about employment, housing, where she's at, what she's doing. She absconded and disappeared for a significant time period in there. His warrant to show cause said that she disappeared after November 30th. This warrant was issued January 5th. That's all of December. He didn't know where she was to the point he issued the warrant, asked for it. She had needed to complete successfully Senate Bill 123. She'd been in and out of different places that he'd arranged for her to go. She did not fully complete her treatment program. She's now out of Senate Bill 123 treatment time. She had a prior revocation on December 1st of 22. She had a sanction in April for 2 days because she did not go to treatment. There's choices and consequences for everyone. I make choices. I have to live with my consequences. Everyone on the screen makes choices and has to live with those consequences. Ms. Swink continually chooses to stop talking to her ISO throughout the entirety of her case. She'll get back on for a little bit because she's in trouble, and then she'll disappear again. We understand that her mental health was an issue, so options were given to her to treat her mental health, and she didn't treat her underlying mental health. She chose not to. This entire supervision, she goes and does what she wants and doesn't think that she has to have consequences for it. Now that she's had a sanction and a first probation revocation, we're up here on a third time of issues. This is her second probation revocation. She just frankly doesn't want to do her treatment and stay in communication with her ISO, which are two of the things that are necessary for her supervision. I don't think I have any choice because she's made the decision she's made, but to ask for an outright revocation and for her to serve underlying time. I don't think I have any other choice at this point.
Very well, Ms. Gillette. I'm going to address Mr. Ketley, the supervising officer, next. I want to give Mr. Favre and his client an opportunity to respond, whatever he may relate to the court. You've been engaged in supervision with this individual for an extended period. Do you have any independent recommendations or remarks, Mr. Ketley?
No, I don't, Your Honor.
All right, Mr. Favre.
Judge, I think Ms. Gillette has highlighted a lot of the shortcomings Ms. Swink has had. I think Ms. Swink, just in perfect candor, has been a little bit, she's a little bit frustrating, Mr. Ketley kind of supervised. I'm not trying to say that to speak ill, but just to recognize the reality of it, of what it is, which is it seems to be one step forward, two steps back, two steps forward, one step back. On one hand, she's completed inpatient. On the other hand, she's for sober living house. She's paid almost all of her case off. She owes $98 owes, which most people make payments. Is now set up her insurance and her have to get her own treatment. Her request today is that the court give her, allow her to finish up treatment on her own dime because she's burnt her Senate bill. She knows she's burnt her Senate bill. And she's finally in a position where she can successfully complete treatment. And just in all candor, I understand why it's a recommendation, but that's the request we're going to make because people take a lot longer to get stable. She seems to be at the point now where she's getting more stable. She has family support, which you can see behind her. We're going to ask for one more chance at probation, even though this is a long case. We ask the court to consider acknowledging some of the positive things that she has done in her case regarding completing inpatient, and consider modifying her sentence if the court is inclined to take the state's recommendation. But that'd be our request today.
Very well, Mr. Favre. At this time, the court will address the defendant, Tammy J. Swink, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present to the court. Ms. Swink?
Yes, sir. I would like to present that in November of 2023, I was working at Smart Style and I was reporting with Ed. It was in mid-December is when I stopped reporting with Ed for those few days. And I did appreciate him reaching out. I was working at Smart Style in Wichita, Kansas and West Kellogg. And I did have jobs. I still have had jobs. I just recently was hospitalized. So therefore I've been without work here just in this little bit, but I'm ready to get back to work. As soon as this heals up, I got bit by a brown recluse and had blood poisoning, was in the hospitalized for 5 days by ambulance. So, also, I've been reporting as much as possible. Even when I was in the hospital, I was letting Ed know, having my mom call. And it's not just when I'm getting in trouble. I feel like Ed really did help me at that point. When he did put the warrant out, it really helped me get back away from a living situation. And I also just been trying, like Joe said, on my own dime, getting it. And now I got all my insurance lined out and my family support, because they really do see that I am not just out playing a game or, being irresponsible. I've been trying to get away from situations to where I can get my things that I need done completed. And that's all I have to say, Judge. And thank you for your time.
See if you can move your mom.
Who's talking?
That's Ms. Swink's mother, Your Honor.
Okay. Ms. Swink, I agree to a very large extent to what Ms. Gillette is saying to the court. When you don't complete your probation conditions, there should be penalties, there should be implications, there should be consequences. You had definite probation requirements to meet, the most fundamental of which is report to your officer as that officer directs. You haven't done that. Further, the entire focal point of your probation in the first place was Senate Bill 123 treatment, and not just one component of it, but a long-term painstaking program to support your rehabilitation. That's what Senate Bill 123 is all about. In fact, the state of Kansas is even willing to invest essentially taxpayer resources to assist you in that regard so that you don't have to go to prison. Rather, be rehabilitated and become a productive member of society. I would have thought you would have understood that by now, that every single component of your Senate Bill 123 treatment program is critical. Ms. Gillette recommends an outright revocation of your probation, which means you go to a women's penitentiary, a women's prison. Mr. Favre, as I understand it, recommends just putting you back on probation and letting you do your treatment. The court's ultimate solution here will be in between. Ms. Swink, there needs to be a serious penalty for noncompliance. This case should have been successfully completed by now. Mr. Ketley's made yeoman efforts to try to make that happen, and you haven't cooperated fully. So the court is going to order, as a sanction for noncompliance, 60 days in the Greenwood County Jail, effective immediately. The alternative would be that you go to prison for much, much longer, Ms. Swink. And then I will reinstate your probation one last time. You're going to need to contact Mr. Ketley with Community Corrections immediately upon your release from the jail, which means either that day you get out or the very next business day that their office is open after you get out. As I often point out to people, it's not his job to track you down again. It is your job to contact him when you get out and that you're free to come report in person.
Yes.
And how would you recommend she do that? What means of communication, Mr. Ketley?
She can call me. She has my phone number. She can call me, Your Honor.
Okay. He's directing a telephone call, and that's what I'll require you to do.
Yes, sir.
I frankly, at this point, it's difficult to know, especially since it apparently took 4 months after this warrant to get you to court, which the court doesn't find particularly acceptable. Nevertheless, I think you need a new assessment from an alcohol and drug treatment provider as to what your current needs are.
Yes.
You say you've completed an inpatient component, which is generally detoxification. That's the purpose of inpatient. It's not really meant to be a long-term solution. So to what extent you need to be attending treatment meetings at this point or aftercare, whatever it's called, I think that needs to be reassessed. And if you're part of an existing program, I'm sure one of their program directors can write an assessment for Mr. Ketley so that he knows exactly what your requirements are at this stage. And I want you to successfully complete those,
Yes, sir.
Ms. Swink, so that you don't have to go to a women's prison.
Yes, sir.
No further costs will be assessed at this point. I don't see that you have the financial resources, wherewithal to be able to pay them. Anything previously assessed, you still owe. I'm also going to extend probation in this case formally to December 31 of 2024 for the rest of this year. You have plenty of time then, even after the 60 days, to get your requirements met, Ms. Swink.
Yes, sir.
And hopefully it will not be necessary to extend your probation any further. Tammy, I'll be honest with you. This is your last chance. I hope you understand that. Either successfully complete the program and probation or do the time. Those are the only options. Is there a law enforcement officer in that room?
No, sir. I think he's out by the waiting thing. You want me to go get him or?
Okay, you need to report immediately to the Greenwood County Jail facility to begin your 60-day sanction period.
Absolutely. Will do.
All right. Ms. Gillette, is there anything further we need to address on Tammy Swink?
I can't think of anything. I was just texting law enforcement.
Okay, thank you.
Yeah, there's an officer here now.
All right.
I'm here, Your Honor.
Okay, thank you very much. She's in custody for the next 60 days.
Thank you, Your Honor.
All right. Mr. Fabre, anything further?
No, Judge, thank you.
Very well. Then the Tammy Swink matter will currently be in recess at this time. We'll move on to another case.
Now, Mandy, you wanted Ms. Williams to get on this hearing, correct?
Yes. Did you ever get a hold of her?
I did. I sent her the Zoom link. So hopefully she'll be getting on here because I sent it to her earlier. She has it. She's had it for a while now.
Okay, the Zoom link on Williams, I think actually had a start time of 11:30, but she's passed that now by 19 minutes.
She's way past it.
But you know, if there's any contact you can make.
Are they not supposed to appear at the courthouse for a show cause?
Did she get told to do that? Because there was some confusion on what she was told.
Well, they should be told that in every single case.
I'm not sure what she was told. Let me see here. Let me make sure I gave her the right Zoom because there was a Zoom for her case separately.
Okay.
Let's see. Nope. No, I did give her the correct Zoom information.
You have a phone number on her, Joe?
I do. She's been texting me all morning. If I could try to call.
Okay. Go ahead and do that. Let's keep the proceeding open for now. He should be right back.
Hi, here I am.
Donna Williams,
Yeah.
you are very late. Let's go ahead and begin this case. It is State of Kansas versus Donna Anita Williams. It's Greenwood County case number 2022 CR 92. Joseph Fabre appears as defense counsel. Jill Gillette is prosecuting attorney. Donna Williams appears on her own Zoom. Ms. Williams, if you can clarify your video where we can see your full face. This matter comes before the court at this time for review of the defendant's sentence on a warrant to show cause alleging probation violation. The request for revocation of probation and subsequent warrant includes failure to obey the law, failure to avoid alcoholic beverages or illegal drugs, failure to pay, fail to not associate with persons on court-ordered supervision or convicted felons, or illegal drug users or people who make alcohol or illegal drugs available. All alleged by Carrie Seeley, the court services officer in the case, pursuant to a warrant to show cause apparently sworn to on or about February 20th, 2024. Fabre, what are your client's intentions regarding the allegations before this court?
So, Judge, proceeding off Ms. Gillette's motion, a revocation and the warrant to show cause issued by Ms. Seeley, she'll stipulate. Sorry, Judge, if we're proceeding off of Ms. Seeley's warrant to show cause, I think she would stipulate to what has been listed by the court and waive a right to an evidentiary hearing on those matters.
Ms. Williams?
Yes.
Yeah, you show that you're muted. Okay, all right.
I'm not muted.
You do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with the assistance of your lawyer, confront their witnesses unless good cause was shown, present your own evidence, and I need to point out to you that among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up in jail. Do you understand this?
No.
I'm sorry?
Yes.
Okay.
Yes.
And do you now waive a formal hearing in this case and stipulate and agree that you committed the violations as the court read off earlier?
Yeah.
All right. The court finds that the defendant has knowingly waived her right to a hearing and stipulates and agrees to the violations as earlier read by the court. The court finds that these are significant and substantial violations of the terms and conditions of Donna Williams' probation in this case. Court will turn to disposition at this point. Ms. Gillette, your recommendations?
Your Honor, Ms. Williams, when she's sober, she does great. When she falls off, she doesn't. So she has a new case that she's picked up here. We currently have a no contact order with her co-defendant, which is another lady around town. She's, I believe, moved to a different area, and she's been back in treatment. I think Ms. Williams needs to have more intensive supervision than perhaps court services has. Because when she has supervision, she usually does well. But she goes off the rails, and that's when she has lots of issues using. This is, I believe, her first time up in this case. I would ask for a sanction on Ms. Williams and for her to be transferred over to community corrections. It's anticipated that her new case will place her on community corrections with an intensive supervision officer at its conclusion. I believe that a sanction would be appropriate for Ms. Williams.
Just a minute, Ms. Gillette. Has that case been disposed of? Is it awaiting sentencing, or what's the status?
We're at pre-arraignment, Your Honor, still in that case.
All right, thank you. Go ahead, Ms. Gillette.
It's anticipated we're in plea negotiations in that case, Your Honor. There's been a plea offer to Ms. Williams. Would like to see her transfer over with a sanction to community corrections, and then have her place. I don't know if she'll need an extension of time in this case. She was sentenced. I was looking at her sentencing date. Her plea and sentencing was June 8th of 2023. It was for a term of 12 months. I would like to see the extension of her probation in this case because it would be up in June next month, to have her get back into treatment. I believe she's already re-entered treatment, but to extend her for at least another 6-month time period and have her go on over to intensive supervision.
Very well. Ms. Seeley, I want to have you address the court next. You've supervised this individual. Do you have any independent recommendations?
Not at this time, Your Honor.
Thank you.
Thank you.
Favre, you may at this time make your recommendations regarding an appropriate disposition.
Judge, Ms. Gillette's correct in the posture of where this case is in regards to the fact this is her first time up. She is also correct regarding the posture of her existing case that we are currently working on a plea on that's not been done, but it is going to end up likely with it being a case where she's placed on corrections. I think the overall statement of Ms. Gillette regarding Ms. Williams on drugs versus off drugs is accurate. She is currently set with a bed date of June 6th. She's also working. So we think the overall recommendation of a sanction and then placing her on corrections is very appropriate given all those factors.
And your fees in the representation of this client?
I don't have them calculated just yet, Your Honor. I would guess not much, probably somewhere in the neighborhood of $250, $300, I would guess.
All right. What kind of job does your client have?
I'm not entirely sure. Ms. Williams, where are you working at right now?
It's a place called Superior. Go around cleaning different businesses and the floors at nighttime. And then some mornings we go in businesses that are open later and gonna clean
Okay, your
floors.
voice is trailing off, Ms. Williams. You're really gonna have to speak up.
I'm sorry. I work for, we clean floors at different businesses.
Okay, how much do you make doing that?
12.
$12 an hour?
Yeah.
Did she answer?
Yes.
Yeah, she said $12 an hour, Your Honor.
Okay. All right, is that full-time then, Ms. Williams?
Yes.
Okay. This time, the court will address the defendant, Donna Anita Williams, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to represent to the court.
I am going to have a bed date of June 6th, but I'm trying to go to another treatment that might be able to get me in sooner. But I do have that bed day and an outpatient. But I am trying to go to inpatient a lot sooner, somewhere else.
Okay. Ms. Williams, were you not told you had to appear at the Greenwood County Courthouse for today's proceedings?
No.
You weren't told that when you made your first appearance?
No.
Normally, Judge Webster does, Your Honor, and I write it down when she says it. For some reason, I don't have it in here, and I don't know if we were in a hurry or if it just got missed in this case, but I usually write it down when it does get in
Very
there.
well, the court will announce its disposition at this time for the substantial material violations of the terms and conditions of probation. The court will impose a 3-day dip sanction on Ms. Williams to effective immediately. Ms. Williams, I'm going to have you report to the Greenwood County Jail by no later than 2:00 p.m. today. Ms. Williams, I want to make sure that I impress upon you what the stakes are here. If you don't voluntarily appear at that jail by 2:00 p.m. today, the Greenwood County Jail in Ricke, Kansas, you'll be back before this court to review your sentence again, and it would be the intention of this court to outright revoke your probation and have you serve it all. If I can't keep you on probation anymore, after you serve this jail time, and I'm presupposing Ms. Williams will report and serve her 3 days, then she needs to report to her court services officer as directed, because the court is not transferring probation in this case. Ms. Seeley is going to keep this case under her supervision. But Ms. Seeley, I'll make the order now that if she is placed on community correction supervision in a felony case, you should immediately transfer the case to that community corrections department on my authority, because I don't want her on dual supervision. But I want you to keep this case until such time, and I'm not going to presuppose she's ever going to get convicted in the other case. But if she is, she's placed on community corrections, then the transfer is to take place. You need any clarification from the court on that, Ms. Seeley?
No, Your Honor. Thank you.
I'm extending her probation in this case for 1 full calendar year. So whatever her original expiration date is extended for 1 full year beyond. And I'll go ahead and announce it for the record. The sentence was pronounced June 8 of 2023. She would have expired otherwise on June 8 of 2024. She's now on probation in Greenwood County case number 22 CR 92 until June the 8th of 2025, unless obviously terminated earlier or otherwise lawfully extended. Regarding additional fees in this case, the court does believe that there should be some financial penalty for having to reappoint Mr. Fabre. I'm going to essentially impose half of what Mr. Fabre quoted to the court as additional fees owed in the case. I'm going to assess an additional $125 of legal fees onto Donna Anita Williams in this matter, waive the remainder. All right, I think I've covered all the necessary aspects of a disposition. Mr. Fabre, are you aware of anything else we need to address here?
No, Your Honor.
Ms. Seeley, are you aware of anything that still needs to be addressed or clarified?
No, Your Honor. Thank you.
Ms. Gillette, anything further?
No, Your Honor. Thank you.
And last and certainly not least, Donna Williams, if you come back on again, do you have any questions about what the court has done today?
No.
Okay, you've got about an hour and 49 minutes to appear at the Greenwood County Jail in Eureka to serve your sanction time. If there's nothing further, then the Donna Williams matter will currently be in recess, and this meeting may be ended for all at this time.